This conference will now be recorded.
Hello, everybody. My name is Tony Fulbright. I hope everybody can hear me well. I am the Deputy State Long-Term Care Ombudsman for Oklahoma. Just to kind of give you a little bit of insight on some of my career, I am currently right around 25 years of state service for the state of Oklahoma within the Department of Human Services throughout many different programs. I have supervised adult protective services. I have supervised adult and family service programs such as Medicaid, temporary assistance to needy families, long-term care Medicaid. I've also been a caseworker in those fields. Okay. And been with the State Ombudsman Office for about 8 years at this point. I want to first start off and let you know that I'm not entirely feeling too well. It's not COVID related. Just bear with me today. I don't have a lot of energy. So just kind of roll with me a little bit. I want to also kind of put this out there that it is basically me doing this presentation. And I know there will be questions. I would prefer that you put those in chat. And then at the end of the presentation, I'll try to go back through chat and address the questions that are there as time permits. We're going to talk a little bit about the Ombudsman program, some of the laws that govern the program. We're also going to talk about residents' rights, and I'll try to give you some example scenarios, and then provide you with some additional information as we go through that might actually help you as an administrator when you get into your current field of work. I'm going to start off. I think everybody can see the first slide. I've already kind of explained who I am. Our office is within the Department of Human Services, Aging Services Division. Right, we used to be housed on 23rd, and currently they have, as you probably are aware, maybe not aware, most DHS employees are now teleworking from home. Our office will continue to do so, but we will have an office at the Sequoia State Office Capitol in Oklahoma City. First off, ombudsman is a strange term for many. A lot of people have not heard that term, including people, residents, family members. I'm sure you may have heard or may not have heard. It's an unusual term. It's actually a Swedish term. In Sweden, at one point when they became a democracy, they incorporated a citizen advocate to be a go-between between the government and the people of Sweden. And this term was actually an ombudsman. Our program uses that title as an advocate for residents. That is our primary source. We are a resident advocate. We are resident driven. We seek resident guidance on any kind of complaints or issues that they may be having. So kind of an odd word, but that's where it's from. I believe I've sent this PowerPoint to Z along with some of the other documents that I'll share today. These are links to certain laws. You're going to see LTCOP enabling, that's long-term care ombudsman program. These are the enabling legislation pieces that allow us to do our job, and it's the law that we follow. Just FYI, we have a link here to the Long-Term Care Ombudsman Act. We also have a link here to the Oklahoma Nursing Home Care Act, the Older Americans Act, which that was a little bit tricky. The link that I had before had sort of disappeared, as you know, links sometimes do. I was able to find a site that you might have to work to get, but it talks about the Older Americans Act and the Ombudsman program within that link. I'll work on that, continue to work on trying to find a better link, but that's the best I could find. And then there's OBRA 87, the Federal Nursing Home Reform Law, with a link there that also cites the Ombudsman program. Other things that we also have is the Oklahoma Administrative Code and the federal regulations. Off the federal regulations, we developed an Oklahoma Administrative Code that has the same force and effect of law. It actually gives clear explanation of our duties off the federal regulations. In 1972, 5 nursing home ombudsman demonstration programs were established to focus on nursing home resident complaint resolution. 1978, Older Americans Act amendments required all states to establish an ombudsman program. The program is designed to be local, community program utilizing volunteers. And we do utilize volunteers when possible in our program. And in 1981, duties expanded to board and care homes, such as assisted living or residential care homes. The name changed from Nursing Home Ombudsman to Long-Term Care Ombudsman, or LTCO, the acronym. In 1987, Long-Term Care Ombudsman access to resident records with resident consent was established, and states must prohibit willful interference of official long-term care ombudsman duties and or retaliation against the ombudsman program, resident or other individuals related to our duties. Sorry about that. Ombudsmen are resident advocates. We can be an impartial mediator, but we're not impartial in complaint resolution work. We do receive guidance from resident, and we try to resolve issues that the resident may be having in facilities. We do try to find ways to meet in the middle if possible, or try to find results. When we talk about mediator, our program does offer mediation services. If you're having an issue with a resident, or you've been working with a resident over a period of time and you're not seeming to find common ground, and you want somebody to be that in-between party to try to come together and find a common ground, as long as the resident consents to our program being there, we can be impartial in that process. Just throwing that out there. Ombudsman must take the resident's perspective in trying to resolve a problem. Again, remember, that is why we are here. The long-term care ombudsman need resident permission prior to investigating a complaint or referring a complaint to another agency. During, of course, and it may be covered on the future slides, but when we get a call of concern from a family member, loved one, friend, or even the facility administrator, we get often calls from facility staff in regards to resident issues or trying to find a way to resolve resident issues. We have to first always see the resident and attempt to get their consent before we can go any further steps. If the resident does have that consenting ability and they tell us that they do not want us involved, then there's nothing more further we can do. So that's something I want you to keep in mind, that if you ever access the Ombudsman program for those type of issues and we come out and we're not able to communicate those things with you, that might be the cause. We have to have their consent before we can share any information. Now, if a resident lacks capacity, in our view, then we'll look towards a legal rep, guardian, power of attorney to seek further guidance. So we do have our own internal steps that we use within our program to address consent. But that is again, with this information, we are resident driven, and we listen to our residents before we take any other steps. The state long-term care ombudsman program, we visit residents again in nursing homes, assisted living, and residential care homes. Of course, currently, COVID-19 has had a factor in us not being able to do so. We've been taking a lot of activity over phone calls and trying to address those kind of issues. I really don't want to get into the COVID-19 situation right now, because I know there's been new updated regulations or guidance from the State Department of Health on visitation that we're all kind of trying to muddle through right now. I know we are entering a lot of facilities again. But again, I don't want to get lost in that today. But I do know this is changing times for everyone, and COVID has definitely played a part in a lot of our duties. Normally, which I don't know what normal is, and I'm not going to say new normal, but I guess I did. But we try to get into facilities 4 times a year to visit with residents what we would consider a routine visit. That's just visiting with residents, trying to get to know them, see if there's any issues that they're having, maybe refer them to outside sources if they're having any issues, or even work complaints as we're in the facility on those visits. We also go in anytime we have a complaint. Anytime somebody has given us a complaint, we have certain timelines that we would typically be out to see them to help resolve those issues. Again, we're not currently able to go in. Well, we are getting back into facilities, but when COVID hit, it did stop a lot of that, and we're doing a lot of things over the phone and trying to handle issues that way. The Long-Term Care Ombudsman Program is mandated by the Older Americans Act. We assist residents of long-term care facilities to obtain the highest possible quality of life and care. Again, long-term care facilities include nursing homes, residential cares, and assisted living facilities. The Office of the State Long-Term sorry again, guys, I'm not feeling too good, but the Office of the State Long-Term Care Ombudsman directly advocates for elders residing in long-term care facilities, as well as administering the Ombudsman program statewide. That does sound redundant. What this is saying that our office, the office that I actually house in, which is with the State Ombudsman, Bill Whited, and 3 program managers that I oversee, we'll often go into nursing homes and work complaints as needed, but we also have oversight of the 27 field staff across Oklahoma that have the responsibility of investigating or helping residents resolve issues in their planning and service areas. Kind of jumped right into the next slide, but we currently have 27 ombudsman supervisors. We do have some vacancies that we've been working on. This data is from 2018. I don't have complete 2019 data available. I was having some issues with our network, so I've left this slide alone. But in 2018, we had conducted routine visits of around 1,846 by our staff. We referred to other agencies like the State Department of Health or the AG's office, Adult Protective Services, or HHS OIG at the federal level. We will refer complaints if there's things that we are not able to resolve that do have a higher priority of attention needed, and let other agencies also come in and investigate those issues if they choose to do so. Back in 18, we had 91 volunteers. That is currently down to about 68. We lost quite a few because of COVID. And it's not only due to COVID, it's because a lot of the volunteers we've had in our program are either retiring or living their own life, or maybe have health issues. That has really dropped our numbers down. But COVID has had a huge play in that. In 2018, our volunteers contributed 6,774 hours to helping residents resolve issues or visiting with residents across the state. There were at least 397 nurse licensed nursing homes in Oklahoma and 227 licensed board and care homes, assisted living, and residential care. In 2018, these are our top complaint codes. Failure to respond to a request for assistance. That could be call lines. It could just be slow responses to resident requests. Medication administration. That covers many different areas from time to wrong meds to no meds. Admission, transfer, discharge, eviction processes. I do have a pamphlet that's electronic that I'll share with you later, and it actually provides you good information on the federal regulations in regards to discharge practices and what's required. But that's always a high category of complaints for our office. And in 2018, we closed 4,198 complaints. So our office does get quite a few complaints during our fiscal year. Again, this is the role of long-term care program. It's important to note that we do not conduct licensing or regulatory inspections or investigations. We are not surveyors. We are not adult protective services. We are knowledgeable of federal and state regulations and will advocate to ensure residents benefit from these laws and regulations. And if necessary, we will file complaints with licensing or regulatory agencies or advise other people how to do that on their behalf. We are not APS, Adult Protective Services. We provide information regarding preventing and reporting abuse, neglect, and exploitation. We will also investigate that on our level. Ombudsman will consult with our state office about abuse, neglect, and exploitation cases when needed. And our program can file complaints about alleged abuse with consent or advise other individuals to do so. This is where I think I'm going to go ahead and throw this kind of out there. This is a little unusual for some people to take in, and I've actually went before this training and pulled down some federal regs that I had saved in my file folders. But our program, the Ombudsman program, is not a mandatory reporter of abuse, neglect, or exploitation. When I used to supervise APS, before I came to the Ombudsman program, I've always been a staunch advocate for mandatory reporting of abuse, neglect, and exploitation. I used to argue with Mr. Whited about that, but when I got into the program and started looking into the federal regulations, it clearly states we have our own processes of how we handle abuse, neglect, and exploitation practices. We have to have certain consents in place to do so. So we are not mandatory reporters. And I know this is usually something that pops up in chat or questions throughout the presentation. So I did a little bit of research, like I said before, and hopefully I can share that with you, at least give you an idea where that's coming from towards the end of the presentation. Today, our program exists in all the states, the District of Columbia, Puerto Rico, and Guam. Under the authorization of the Older Americans Act, each state has an Office of the State Long-Term Care Ombudsman, headed by a full-time state ombudsman. Thousands of local ombudsman staff and volunteers work in hundreds of communities throughout the country as part of the statewide ombudsman programs, assisting residents and their families and providing a voice for those unable to speak for themselves. Okay, I'm currently up to my residents' rights portion of the PowerPoint. I believe that you were able to watch a little bit older video of residents' rights before. I think Z was able to put that on or share a link with you prior to this this training. It's a little dated, but it did have Esther Hauser and Dory Huser, former Chief of Long-Term Care, Dory Huser with the State Department of Health, and Esther Hauser, who was the first state ombudsman for Oklahoma, was the state ombudsman for, I don't want to get that wrong, but 20, 30 years, and I'm probably getting that wrong. I did have the opportunity to work with her before before I left and came back, and then she retired. Very great advocate, very hardworking advocate, very impressive lady. So I'm going to just quickly, before we get into residents' rights, it looks like I said I was going to save it for the end, but I think I'm going to look at the chat questions if I can pull those up without messing anything. Okay. Okay. No, there were nothing there important to go over. All right. It's not wanting to go. Sorry, everybody, it's not wanting to access through. So let me get in here. Okay. Let me go back to seeing if I can share that screen. Really? Just a minute, please, everybody. I'm give me a chance here. See if I can get this thing started back up. Is that showing up? I hope it is. All right. Under residence rights, under the Oklahoma Nursing Home Care Act, I'm going to read through these, kind of give you some examples as we go. I believe you can see that because I can see my screen showing that to you. All principles enumerated in this section shall be posted in a conspicuous, easily accessible location in each facility. Each resident and personally appointed representative of the resident, if any, shall be verbally advised and provided a written copy of such principles prior to or upon admission to the facility. The facility shall ensure that its staff is familiar with and observes the rights and the responsibilities enumerated in this section. The facility shall make available to each resident, upon reasonable request, a current written statement of such rights and responsibilities. There's a lot of stuff in there. But one of the things I want to point out that we've kind of seen at times is when it says these rights need to be posted in a conspicuous, easily accessible location in each facility. That needs to be, like it says, in an area where they can be found. And most often it's that way. But we've also found them in, break rooms or front lobbies that residents may not have access to. Just keep in mind that needs to be accessible for the residents. And also it needs to be given to them at time of admission and any time that they request that. Really. Every resident's civil and religious liberties, including the right to independent personal decisions and knowledge, shall be available, and of available choices shall not be infringed upon, and the facility shall encourage and assist in the exercise of these rights. Every resident shall have the right to private communications, including telephonic communications and visits, and consultations with physician or an attorney, and meetings of family and resident groups or any other person or persons of the resident's choice, and may send and promptly receive unopened the resident's personal mail. Now, there's a lot of things to cover in that section. Every resident shall have the right to private communications, including telephone and visits, either with a doctor or attorney or with anybody they basically choose to have those visits with. I do have a document that I'll share with you later that was also, I believe, sent out by Z in regards to restriction of visitation. This is going to be an issue that you're probably going to come across in your facilities, either from family members wanting to restrict somebody from coming to see their loved one, or even a power of attorney or a guardian, or maybe even you. Now, I need to clarify here in regards to that, and I have the AG's opinion, even in regards to guardians. A guardian, a power of attorney, a legal rep cannot restrict visitation of others to see the resident if the resident chooses to want to see them. Again, this is going to be something that probably does come across your desk at some point in time. Like I said, I've noticed this has been a hot topic or a question before in previous presentations, so I've attached to or gave the AG's opinion. I also have it if we need to pull it up and take a look at it. But it clearly states that a guardian cannot do that. Now, this does not preclude somebody from coming into your facilities and affecting resident care or threatening people or causing those kind of issues. You have, as an administrator, you do have responsibility of care and oversight in your facilities. That also includes the safety of those individuals there. If that's the case, then they can be asked to leave. No one's guaranteed that right if they're putting other people in danger or in issues of those types. So you have that right to restrict that at that visit if that becomes a problem. Now, one of the things that I will usually on a consultation type, and that's something I want you guys to understand also. Our office isn't a resident advocate, but we get lots of calls from staff and facilities, administrators who aren't afraid of our program and reaching out for policy law interpretation or those type of things. That's what we're here to. We're here to help provide that information to you that will help better your facility as well. So please keep us in mind when it comes to those type of issues. But and this is something I've had conversations with multiple times with administrators in regards to, someone that's either infringing on other people's rights or causing harm or other issues of resident care, or even the resident themselves. If the police need to be called in to help protect a resident, then there's going to be a police report somewhere about those issues, possibly there should be. And if it's at that level where this person is causing this type of damage or issues and you're looking at protecting others in some restricting way, that police report could be used to get a protective order. And a protective order is a court order. Again, I'm not trying to give that information to preclude a resident from seeing their loved ones, but I also understand in your situation that there's going to be situations that pop up like this. So that might be something to consider down the road. Also, a resident does have the right to open their own mail. That doesn't mean the facility gets to open it before the resident gets it. The resident does get to open their own mail. They also have a right to have consultation with their own physician. Yeah, I understand that there's a medical director, and we understand that over the facility. That doesn't preclude a resident's ability to have their own communications with their own physician. Hopefully that physician will also work under the guidance of the medical director, and it'll work out to be a fine process, but residents do have a right to visit with a doctor that they choose to, and they also have a right to talk to an attorney if they choose to. They're also allowed to have meetings of family or resident groups, like resident councils. And nursing homes, that's a requirement. It's usually on every activity calendar. But there's also family councils. So there's a lot of stuff written into this one that I just covered. Every resident shall have the right, without fear of reprisal or discrimination, to present grievances with respect to treatment or care that is or fails to be furnished on behalf of the resident or others. The facility staff, the facility's administrator, the facility's attending physician, the resident's personal physician, if any, government officials, or any other person, and to organize or to join with other residents or individuals within or outside the facility to work for improvements in residents' care. Again, pertaining to resident or family councils. family of a resident shall have the right to meet in the facility with other residents' families. Every resident shall have the right to prompt efforts by the facility to resolve grievances the resident may have, including those with respect to the behavior of other residents. Every resident shall have the right to manage such resident's own financial affairs, unless the resident delegates that responsibility in writing to the facility. The resident shall have at least a quarterly accounting of any personal financial transactions undertaken in the resident's behalf by the facility during any period of time the resident has delegated those responsibilities to the facility. Now, in nursing homes, maybe not in other types of facilities, it's kind of a common practice to have a resident trust set up, and residents are given an option to whether or not they want to turn their funds over to the trust, and that helps pay their co-pays and helps with some management responsibilities of the money, and that is a resident's choice. That's one thing I want to make clear here. There is no mandated requirement for that to happen. But to keep in mind that if you do have that responsibility turned over to you, that they are entitled to get a quarterly accounting, and any time that they request to have an accounting, they should be given that. Every resident shall have the right to receive adequate and appropriate medical care consistent with the established and recognized medical practice standards within the community. Every resident, unless adjudged to be mentally incapacitated, that's by a court, shall be fully informed by the resident's attending physician of the resident's medical condition and advised in advance of proposed treatment or changes in treatment in terms and language that the resident can understand, and to participate in the planning of care and treatment or changes in care and treatment. Every resident shall have the right to refuse medication and treatment after being fully informed of and understanding the consequences of such actions, unless adjudged to be mentally incapacitated. There's a lot of stuff in there. One of the things, again, I'm going to kind of go over this just a little bit, but when it talks about planning of care plans, residents have a right to be part of their care plan. In regards to medical practices, appropriate medical practices, they are entitled to receive appropriate medical care. In regards to rights to refuse medication, it does clearly state that, and that was part of the video process that we had earlier. But I kind of want to throw out a little bit of an example that might get some concerns raised up. And I know I'm not going to answer any questions right yet, but I'm just going to throw this out there and I'll kind of answer my own question. What if a resident wants to refuse dialysis? You know, it could be a life-ending consequence if they choose not to do so, if they choose to refuse it. Maybe they refuse their chemotherapy treatments or some other type of diabetic medicine, or choose to eat a hamburger or chocolate when they have diabetes. A resident does have the right to refuse those. That doesn't preclude the facility or the staff from talking about consequences with the resident, addressing those possibly in a care plan. Now, one of the things that I would advise, this is in a consultation process here, is that there's some concern that this is putting an individual at risk of harm or death. That's considered self-neglect in the adult protective services world. And as a mandatory reporter, that's a report that you probably should be making, well, you should make to adult protective services or law enforcement according to Title 43A in regards to abuse, neglect, and exploitation. So I would, again, when you're documenting these things in refusal processes, it's probably in your best benefit to make that report to APS or law enforcement, again, according to Title 43A. And in those type of situations, a call to the ombudsman to come out may help resolve some stuff. It may not, but it's not worth a try. We may be able to talk to the resident and help with understanding, or maybe help the resident and not being fearful, whatever the case may be. So just please keep this in mind. We don't always need to be seen as an enemy. I'm not saying we are, not in any form. We're here to help resolve some of your problems too that you may be having, as long as the resident wants that resolved. So please keep that in mind. Every resident shall receive respect and privacy in the medical care program of the resident. Case discussion, consultation, examination, and treatment shall remain confidential and shall be conducted discreetly. Personal and medical records shall be confidential and shall include such documentation or information so as to alert a healthcare provider or an emergency medical care facility of the existence of a directive to physicians for a living will. One of the complaints that we get quite often in a facility, and something that as an administrator to be mindful of, is, I'm not saying it happens everywhere, but it does happen, conversations at nursing stations involving residents' records, residents' care in front of other people. And sometimes it may just be something that they don't even know that they're doing. Please keep that in mind, that is a confidentiality breach. Example number 2 is if you have a med card out or whatever going down the hallway and you're leaving your med book open with residential information out there for anybody to see to pass by, that also needs to be considered. Every resident shall have the right to reside and to receive services with reasonable accommodation of individual needs and preferences, except where the health and safety of the individual or other residents would be endangered. Every resident shall be informed by the facility at the time of admission of the facility's policy regarding the provision of hospice services. The facility's policy shall specify whether the facility provides hospice services, either directly or through contractual arrangements with other hospice providers. Specify whether the facility permits hospice services to be provided. And I'm about to possibly try to pull up the Hospice Act that was passed, I believe, 2 or 3 years ago in regards to what is required for nursing homes to offer hospice. So this is a little bit outdated on this end, but it hasn't officially been rewrote into the rights, but it's there. Ooh, now you want it to work. That's amazing. Again, each resident shall receive a list of hospice services from which the facility contracts, and complete disclosure shall be provided to the resident regarding the facility's relationship with any hospice service that is a result of the ownership or an ownership interest of 5% or more. Now I'm going to try, without butchering this up again, share a document. Let's see if that pulls up. Right there, share. Okay. This is the Hospice Act. Again, I want to kind of go through some of this, and most of this we're going to just pull right by. I don't know if it's going to have to catch up as I share. Yeah. But I'm going to move to the section in regards to hospice services. And then we'll let the screen catch up, hopefully, so you can see what I'm seeing. This has been built into that residents' rights section we were just going over. Now, here's the change that was made. If the facility provides hospice services through contractual arrangements with hospice providers that does not contract with at least 3 entities providing hospice services within a 50-mile radius of the facility, it shall means it's required, upon the request of the current facility resident, contract with an additional hospice provider within a 50-mile radius of the facility as necessary to provide the resident with a choice of 3 providers. This requirement shall cease to exist when the requesting resident is no longer in the facility. So this was changed through legislation. Basically, like it says, is to allow residents choice of hospice. Before, a facility could contract with one hospice provider, or not even contract with the hospice provider and just do palliative care themselves. This was a change. So I'm not sure eventually when you're in your own facility or operating your own facility and you're looking at your policies, if you only contract with one, that's fine. It doesn't say that you have to do that, but if somebody comes in here, well, it does say that if you don't contract with at least 3 entities, that upon request of a resident, again, as long as let me read that again, at least 3 entities providing hospice services within the 50-mile radius, it shall, upon request of the current facility resident, contract with an additional hospice provider within that area to provide the resident with a choice of at least 3 providers. So if your contracts are less than 3, say you have a contract with 1 or 2, but somebody doesn't want to use that hospice, and there's another provider in that 50-mile radius that they would like to use, then you should have a contract with that developed with that hospice provider so the resident has their choice. But as soon as the resident leaves or deceases, then that contract expires and can be done away with. So you don't have to maintain that contract permanently. It can be done away as soon as the resident either leaves or no longer in the facility. Every resident shall have the right to receive notice before the room or roommate of a resident in the facility is changed. Now, if the resident has a telephone in his or her room, the resident must be informed of any charges to be incurred. Every resident shall have the right to retain and use personal clothing and possessions unless medically contradicted, and shall have the right to security and storage and use of these clothing and possessions. I believe in the regulations, when there's a room change, the resident has to be given 48 hours notice, but they are to receive a notice of room change. That's pretty simple there. Nothing really too much to go into. Every resident shall have the right to receive courteous and respectful care and treatment, and a written statement of the services provided by the facility, including those required to be offered on an as-needed basis, and a statement of related charges, including any cost for services not covered under Medicare and Medicaid, or not covered by the facility's basic per diem rate. Every resident shall be free from mental and physical abuse and neglect and corporal punishment, involuntary seclusion, and from any physical or chemical restraints imposed for the purpose of discipline or convenience, and not required to treat a resident's medical symptom, except those restraints authorized in writing by a physician for a specified period of time, or as those necessitated by an emergency, where the restraint may only be applied by a physician, qualified licensed nurse, or other personnel under the supervision of a physician, who shall set forth in writing the circumstances requiring the use of restraints. Every resident shall receive a statement of the facility's regulations and an explanation of the resident's responsibility to obey all reasonable regulations of the facility and to respect the personal rights and private property of other residents. Every resident shall receive a statement that, should they be adjudicated incompetent and have no ability to be restored to legal capacity, that the above rights and responsibilities shall be exercised by a court-appointed representative. So This also kind of goes in an area where if the facility has regulations, which almost all facilities have their own facility regulations, the resident should abide by those as long as it's not contradicting other federal or state law. No resident shall be required to perform services for the facility. Every resident shall have privacy for spousal visits. Every resident may share a room with the resident's spouse if the spouse is residing in the same facility. When a physician indicates it's appropriate, a facility shall immediately notify the resident's next of kin or representative of the resident's death when the resident's death appears to be imminent. Every resident shall have the right to participate in social, religious, and community activities that do not interfere with the rights of other residents in the facility. Every resident shall have the right to examine, upon reasonable request, the results of the most recent survey of the facility conducted by the State Department of Health with respect to the facility and the plan of correction in effect with respect to the facility. No licensed facility shall deny appropriate care on the basis of the resident's source of payment, as defined in the regulations. Appropriate care shall not include duplication of services by a nursing home, hospice, or any combination of care providers. This is something I do want to address a little bit, and it may seem reasonable or whatever. If a resident, say, was admitted to your facility and a Medicaid application was denied, and now you no longer have a pay source, which may be common through the years with nursing home administrators, that doesn't mean that the resident, while you're either attempting to discharge or whatever the situation may be, the facility still has to provide the medical care that's required of the resident, regardless if they have a pay source or not. So that's kind of what this is saying here. So if they're in your facility and they need care, they should be given care. Each facility shall prepare a written plan and provide appropriate staff training to implement each resident's rights as stated in this section. And at this point, I usually will always throw out the fact that our program does offer in-service training in this area. We would be glad to have that for you. I know with COVID again, there's been with our inability to get into facilities, and issues have come to situations where it's restricted visitors. A lot of that is starting to loosen up some. We are here offering in-services in this area, along with abuse, neglect, or exploitation, or other issues that residents or staff may be needing, that we are prepared to provide that to you. We can also do that through Zoom or other platforms possibly to help you out. So keep us in mind when it comes to in-services, because this is kind of what it's saying here, written plan to address those. We'd be glad to do that for you if you feel like you need that service. Any person convicted of violating any provision of this section shall be guilty of a misdemeanor, punishable by a fine not less than $100, no more than $300, or imprisonment in the county jail for not more than 30 days, or by both such fine and imprisonment. And how to reach an ombudsman. This is my contact information. I will give you my work cell. That does have our office number there, and it has my email address, which is still very usable. The address for us has changed. Like I said, we now receive our mail and have an office at the Sequoia State Office Capitol in Oklahoma City. My work cell is 405-664-2244. I'm not done yet. I've still got some things I want to cover, but just throwing that out there for you. 405-664-2244. And I'd be glad to help assist if there's something we can help you, provide information, consultation to, or some things that we might be able to give you a little guidance on. That's never a problem. And there's also a number below, and these numbers can get you to your local ombudsman supervisors in your areas. 1-800-211-2116, or call 211 for contact information. One of the things, now that that PowerPoint is over, I'm going to try to close that out. Then I want to go back to some of these forms that I had pulled up that I wanted to share with you. I had mentioned before restriction of visitation and how a resident has a right to have visitors of their choice. And again, an area that you're going to see this happen from either family members upset with other family members, or whatever the situation is, or maybe even disruptive or issues in your facility and you're wanting to restrict them. I wanted to make sure, and Z has this for you. I imagine he probably emailed that out before, but this is the Attorney General's opinion in regards to restriction of visitation, and that a guardian, even a guardian, cannot restrict visitation. I have highlighted a couple spots right here in plain statutory language of the Act. It does not provide a guardian the power to restrict or terminate visitation. This is the AG's explained opinion in regards to this. Also, a review of Title 30, that's the Title 30 is the guardianship law, reveals that the Oklahoma legislature, when they put together these issues, did not provide a guardian with the statutory authority to restrict or terminate visitations. And again, it says the enumerated duties limitations both indicate legislature did not intend for guardians to be able to restrict these visitations without a court order. And at the end here, where it says basically let it catch up, I think. Got to catch up a little bit. Specifically, it affirms that without a court order, and in this case, an order that's sufficient basis, the ward or the resident has the right to choose with whom he associates. With the Oklahoma Guardianship and Conservative Act, it does not provide a guardian with the power to restrict or terminate visitation without a court order, such as a remedy where necessary may be sought by the courts. Let this catch up a little bit. A little slow, dragging. Okay, and here at the end, it is therefore the official opinion of the Attorney General that, one, a guardian has no powers except as provided by the Guardianship and Conservator Act by court order or by court orders. Title 30 does not provide a guardian with the power to solely and without a court order restrict, terminate visitation with a nursing home resident or any other vulnerable adult. So if you're having these issues at your facility and you're having some problems with the family or family fighting or those kind of issues, or maybe even a guardian trying to restrict somebody from coming, keep this document handy. You can provide this to families. Again, it's a document. It's the AG's opinion. So keep this handy in case you need this in the future. I just thought it'd be good for you to have. Let me share this. There we go. Sorry about a little bit of the drag. Right here is the federal regulations that I was able to on short notice. I thought it just might help to have this in regards to mandatory reporting. Again, I know we have questions in that area sometimes. So I just want to pull out this document. This was the revised 2017. I know it's been revised further, but our portion has not changed. And just bear with me as I come down to the portion in regards to just bear with me. I am going to send this to Z also. I did not send this previously, just in case you wanted this document. It's not an official document, but it's got the regulations on it in regards to our program. And off these regulations, we then, our office turned around and wrote Oklahoma Administrative Code. And code is the same full and effective law that is codified by the legislature that we can follow from the state angle. Okay, let's let this catch up right there. And again, this is in the section about official ombudsman duties. Again, I don't want to read through all these, but it basically says here, in order to comply with the wishes of the resident, the ombudsman rep of the office shall not report suspected abuse, neglect, or exploitation of a resident when a resident or resident rep has not communicated informed consent. So that right there shows you basically that we can't provide, we cannot report abuse unless we have consent of certain parties. And it goes on here and it goes talking about even, again, releasing resident identifying information. We can't do that without consent. Also, if the page catches up, it talks right here in regards to, again, same type of language. But even in the section right here on 8, right here, I don't know if it shows it or not, pulls that up. Even witnessed abuse. We could actually witness abuse and we still cannot report that to APS or law enforcement without resident consent. Or if the resident lacks that consent, their rep. Now, I want to make sure that you do understand that that doesn't mean that we won't. If we don't have a resident or somebody that, if they don't have a rep either, this down here does allow the state ombudsman, Bill Whited, or his designee, which is me, to give authority and approval to go ahead and refer that to other agencies to investigate. The point of this right here is that I've always had questions here, and people are a little shocked when they hear the ombudsman is not a mandatory reporter. I just want you to understand we're not. So if you're trying to report that type of abuse, you need to document your reported abuse according to Title 43A to Adult Protective Services or law enforcement. Because saying you just advise the ombudsman program is not going to be sufficient. Next thing I wanted to share with you is a transfer discharge pamphlet that we created when the new federal regulations came out in regards to transfers and discharges. We sent this to every nursing home in the state of Oklahoma. I'm not sure if we sent to, of course, assisted living has a little bit slightly different policy, but this was sent out to all nursing facilities in Oklahoma, and we passed this out to different agencies, residents, whoever it may come upon that needs this information. And this may be helpful to you. It really would be helpful as a new administrator, especially if you're in a nursing home. Z has this document. I sent it to him. He should, maybe he's already forwarded it to you or not, but it's good to keep. It does have guidance in understanding language from the federal regulations and requirements that you must follow in order to have a correct discharge. There's a fax to know sheet where you can call our program, or tells about the appeal rights, discharge notice, 30 days guidance. Over here on the right, it talks about reasons for a valid discharge. As you scroll down, there's tips and facts that go along with what might help you with discharge planning or residents themselves. Again, this is really a resident-driven pamphlet, but there's knowledge in here to help you do a correct discharge. Tells you when a written notice is required, what should be in that notice, and how it should be given to the resident or the resident's rep, at least 30 days prior to discharge date. And the listed location where they're going to be discharged to needs to be specific, appropriate, available, and agreeing to admitting the resident. Again, I'm not going to read over the whole document, but I do find that it's really helpful to future administrators or current administrations just to have it handy so that you kind of have that right at your tip of your fingers or if you have somebody that actually works on those for you and gets those discharge letters out. In the back of this pamphlet, again, there's some more links. I haven't checked to see if these are still current. I know it talks about the Oklahoma nursing home regulations. I will tell you that I'm sure that you may already do this, but I find that the State Department of Health's webpage is excellent on having the different laws that govern long-term care facilities in Oklahoma that are easily handled. It's www.ok.gov/health. If you go to their homepage, there's links on the left-hand side that say protective health. If you click on that link and then click on long-term care service, I believe, it'll take you to a page of different laws that cover long-term care facilities in Oklahoma, according like the Nursing Home Care Act, the specialized regulations, the Residential Care Act, the CC and Assisted Living Act, rules and regs are all in there. Now, I like that because if you use that as a standard page to go to review it, instead of picking up a gigantic manual like I have throughout my office, you can do a search, just right-click in the document, and it'll do a find. You can do a find and find keywords that'll pull it up pretty fast for you if you're needing that law and policy guidance. So again, you may already know that. I like to throw that out there because I use it quite frequently when I train or if I need to find something very quick. But again, on this document, there's some links that you can follow, or whoever wants to go look at those things can follow. And again, has different sites. You can find regulations, involuntary transfer and discharge questions, and so forth. Okay. I am done with that portion. I am going to go ahead and look at chat. I guess it's the same thing. Does anybody have any questions? I wanted to leave about 10 minutes at the end if anybody had any questions that they would like to throw at me or try to get me to get some more information on. I'd be glad to take those. If you want to throw it in chat real quick, that's fine. I guess if you want to unmute yourself, I'd take a question if you have that. Well, I usually have a lot of questions. Anybody?